What are the civil rights obligations of state administering agencies? This training segment, presented by the Office for Civil Rights, Office of Justice Programs, U.S. Department of Justice, provides an overview of the obligations and responsibilities that state administering agencies, or SAAs, have under the applicable civil rights laws. The first part of this online training program addresses the obligations that SAAs have to comply with the applicable federal civil rights laws. The second part of the training program focuses on the responsibility that SAAs have to monitor subrecipients to ensure that they are also in compliance with the same federal civil rights laws. An SAA is a component of state government that receives financial assistance from the Justice Department and then makes subawards to other state agencies, units of local government, such as county or municipal agencies or Indian tribes, or nonprofit organizations. The term subrecipient refers to the organizations that an SAA funds with Justice Department resources.
As we noted in the introduction, an SAA that receives funding from the Department of Justice must ensure not only its own compliance with applicable civil rights laws, but also the compliance of its subrecipients, vendors, and contractors. To understand the applicable civil rights laws, you may want to view the separate online training video that the Office for Civil Rights has prepared that provides an overview of the laws that apply to recipients of federal financial assistance from the Justice Department. An SAA must ensure its own compliance with applicable civil rights laws by 1. Providing notification that it does not discriminate, 2. Taking reasonable steps to provide meaningful access to its services to persons with limited English proficiency, or LEP, 3. Submitting to the Office for Civil Rights any findings of discrimination from a court or administrative agency issued within the past 3 years, 4. Formulating an Equal Employment Opportunity Plan, or EEOP, if required to do so. 5. Designating a coordinator to handle discrimination complaints and adopting grievance procedures, if required to do so under Section 504 of the Rehabilitation Act, the Americans with Disabilities Act, Title IX of the Education Amendments, or the Juvenile Justice and Delinquency Prevention Act. 6. Developing written grievance procedures for receiving discrimination complaints, and 7, ensuring that it does not discriminate for or against an applicant or subrecipient on the basis of religious character or affiliation. We will discuss each of these items in more detail.
To ensure its own compliance with the applicable civil rights laws, an SAA should provide notification to its employees and beneficiaries and to the employees and beneficiaries of subrecipients that it does not discriminate on the basis of race, color, national origin, religion, sex, disability, or age, and that it does not retaliate against persons who file a discrimination complaint or lawsuit, who complain to the SAA or the subrecipient about discrimination, or who participate in a discrimination proceeding, such as being a witness in a complaint investigation or lawsuit. SAAs should be aware that national origin discrimination includes discrimination on the basis of limited English proficiency, or LEP. An LEP person has a first language other than English and a limited ability to read, speak, write, or understand English. An SAA, if it is a direct service provider, must take reasonable steps to provide meaningful access to LEP persons. Meaningful access may entail providing language assistance services, including oral interpretation and written translation where necessary. The Office for Civil Rights encourages SAAs to consider the need for language services for LEP persons.
The Office for Civil Rights strongly encourages federally funded SAAs that provide direct services to the public to develop language access plans to 1. Ensure consistent application of policies and practices, so when an LEP person seeks services from the federally funded organization, everyone in the organization will know how to provide the services, and the services will be provided consistently. 2, provide training to employees on how to best serve LEP individuals. And 3, inform LEP persons about available language services. Information on a recipient's obligation to provide language services to beneficiaries and assistance in developing a language access plan is available online at www.lep.gov. The Office for Civil Rights has prepared a separate online training segment for recipients and subrecipients on their obligations under applicable civil rights laws on serving LEP beneficiaries. Under the implementing regulations for the Safe Streets Act, state administering agencies have an obligation to send to the Office for Civil Rights any adverse findings of discrimination based on race, color, national origin, sex, or religion issued within the past 3 years by a federal or state court or a federal or state administrative agency after a due process hearing.
SAAs should also be aware of their obligation to formulate an Equal Employment Opportunity Plan, or EEOP, in accordance with 28 CFR Part 42, Subpart E. An EEOP is a comprehensive document which 1. Analyzes an agency's workforce in comparison to relevant labor market data, 2. Analyzes an agency's employment practices to determine their impact on the bases of race, sex, or national origin, and 3. Is a tool to identify possible problem areas where employment discrimination may be occurring. If an SAA is not required to formulate an EEOP, it should submit a certification form to the Office for Civil Rights indicating that it is not required to develop an EEOP. If an SAA is required to develop an EEOP, but is not required to submit the EEOP to the Office for Civil Rights, the agency should submit a certification form to the Office for Civil Rights certifying that it has an EEOP on file that meets the applicable requirements. If the SAA receives a single award in the amount of $500,000 or more under the Safe Streets Act, the Juvenile Justice and Delinquency Prevention Act, or the Victims of Crime Act, and has 50 or more employees, it should submit a copy of the EEOP short form to the Office for Civil Rights. Additional information on the EEOP requirements is available at the website of the Office for Civil Rights, www.ojp.usdoj.gov/about/offices/ocr.html. The Office for Civil Rights has prepared separate technical assistance materials that are available online to assist recipients and subrecipients in complying with the EEOP requirements.
The implementing regulations for 4 federal laws require some recipients of Justice Department funding to designate a civil rights coordinator and adopt grievance procedures. 1. Section 504 of the Rehabilitation Act of 1973. 2. Title II of the Americans with Disabilities Act of 1990. 3. Title IX of the Education Amendments of 1972. And 4. The Juvenile Justice and Delinquency Prevention Act of 1974. Section 504 of the Rehabilitation Act prohibits discrimination on the basis of disability. The Department of Justice's implementing regulations for Section 504 requires that recipients with 50 or more employees who receive federal financial assistance from the Department of Justice of $25,000 or more 1. Designate a Section 504 coordinator who is responsible for coordinating the agency's efforts to comply with Section 504 of the Rehabilitation Act, including investigating complaints of disability discrimination. 2. Adopt grievance procedures for the prompt and equitable resolution of complaints alleging disability discrimination. And 3. Notify program participants, beneficiaries, applicants, employees, unions, or professional organizations holding collective bargaining or professional agreements with the recipient that the recipient does not discriminate on the basis of disability. Recipients and subrecipients should also provide notice to interested parties on how and where to file a disability discrimination complaint.
The Department of Justice's implementing regulation for the Americans with Disabilities Act requires that public entities that employ 50 or more persons, regardless of the amount of federal funding received, designate a responsible employee as disability coordinator and adopt grievance procedures. Under Title IX of the Education Amendments of 1972, recipients of federal financial assistance from the Department of Justice cannot discriminate on the basis of sex in educational programs. The implementing regulations of Title IX, like the implementing regulations for Section 504, also require recipients implementing educational programs to 1. Appoint a Title IX coordinator, 2. Implement grievance procedures for filing Title IX complaints, and 3. Notify interested parties that the recipient agency does not discriminate on the basis of sex. The implementing regulation for the Juvenile Justice and Delinquency Prevention Act, 28 CFR Section 31.202, requires certain state administering agencies that receive funding under the statute to designate a civil rights coordinator who is responsible for ensuring that all civil rights responsibilities are being met, to include notifying the public and subrecipients of the right to file claims with the Office for Civil Rights and complying with the EEOP requirements.
The Office for Civil Rights recommends that SAAs have a civil rights coordinator in place not only for complaints alleging disability and sex discrimination, but also for all other discrimination complaints related to other federally protected classes, which include race, color, national origin, religion, and age. Complaints may also allege retaliation. An SAA should also have written procedures for receiving discrimination complaints not only from employees and beneficiaries of the SAA, but also from the employees and beneficiaries of its subrecipients.
The SAA's written policy for addressing discrimination complaints should include, at a minimum, the following elements. 1. Designating a coordinator who is responsible for overseeing the complaint process. 2. Notifying the SAA's employees, as well as beneficiaries and subrecipients, of prohibited discrimination and its policy for handling discrimination complaints. 3. Establishing written grievance procedures for handling discrimination complaints not only from the SAA's employees and beneficiaries, but also from its subrecipients, employees, and beneficiaries. 4. Developing complaint procedures that have one of three options. A. Having the SAA investigate the complaint itself. B. Referring the complaint to another state or federal agency, such as a state's Human Rights Office or the federal EEOC. Or C. Referring the complaint directly to the Office for Civil Rights. 5. Notifying the Office for Civil Rights whenever the SAA investigates the complaint itself or refers the complaint to a federal or state agency. And 6, training staff on the responsibility to refer discrimination complaints or potential discrimination issues to the complaint coordinator as soon as the alleged discrimination comes to light.
SAAs should also be aware that according to the implementing regulations for both Title VI and the Safe Streets Act, a recipient may not, directly or through contractual or other arrangements, utilize criteria or methods of administration which have the effect of subjecting individuals to discrimination. It is the longstanding policy of the Office for Civil Rights to view recipients that lack civil rights grievance procedures as using methods of administration that have the effect of substantially impairing the accomplishment of the objectives of a funded program as respects individuals of a particular race, color, national origin, sex, or religion. For sample complaint procedures, see the website of the Office for Civil Rights under the heading Resources, Sample Documentation. State administering agencies must not discriminate either for or against an applicant organization or a subrecipient on the basis of religious character or affiliation. SAAs cannot designate a certain amount of federal funding to support faith-based organizations, nor can SAAs exclude otherwise eligible faith-based organizations from applying for program funding from the Justice Department. In addition to monitoring its own compliance with applicable civil rights laws, SAAs must also monitor their subrecipients, vendors, and contractors to ensure that they are in compliance with the civil rights laws.
Subrecipients have the same civil rights obligations as SAAs. Just as the SAA has to make sure that it is itself in compliance with federal civil rights laws, the SAA has an obligation to monitor its subrecipients to ensure that they are also in compliance with the same laws. The SAA is responsible for monitoring its subrecipients to ensure that they 1. Provide notification that they do not discriminate. 2. Take reasonable steps to provide to persons of limited English proficiency meaningful access to the subrecipient's services or benefits. 3. Submit to the SAA or to the Office for Civil Rights adverse findings of discrimination from a court or administrative agency after a due process hearing. 4. Formulate an Equal Employment Opportunity Plan or EEOP if required to do so. 5. Designate a coordinator to handle discrimination complaints and adopt grievance procedures if required to do so under Section 504 of the Rehabilitation Act, the Americans with Disabilities Act, or Title IX of the Education Amendments. 6. Have written procedures in place for receiving discrimination complaints. 7. Sign standard assurances that refer to all applicable federal civil rights laws and regulations. And 8. Comply with the Justice Department regulations applicable to faith-based organizations.
State administering agencies should monitor each of its subrecipients to ensure that each subrecipient is providing notification to its employees and beneficiaries that the subrecipient does not discriminate on the basis of race, color, national origin, religion, sex, disability, or age, and that it does not retaliate against persons who file a discrimination complaint or lawsuit, who complain to the SAA or the subrecipient about discrimination, or who participate in a discrimination proceeding, such as being a witness in a complaint investigation or lawsuit. State administering agencies should monitor each of its subrecipients to ensure that each subrecipient is taking reasonable steps to provide to persons of limited English proficiency meaningful access to services or benefits. As previously discussed, meaningful access may entail providing language assistance services, including oral interpretation and written translation, where necessary. SAAs should inform their subrecipients that information on LEP obligations can be found at www.lep.gov. The Office for Civil Rights has prepared a separate training segment, available online, that provides more detailed information regarding national origin discrimination under Title VI in the Safe Streets Act as it relates to LEP persons.
SAAs should monitor each subrecipient that receives funding subject to the Safe Streets Act to ensure that each subrecipient submits to the Office for Civil Rights any adverse findings of discrimination issued within the past 3 years based on race, color, national origin, sex, or religion from a federal or state court or federal or state administrative agency after a due process hearing. To ensure that the subrecipients comply with this requirement, many state administrative agencies collect the adverse findings directly from their subrecipients and then forward the adverse findings to the Office for Civil Rights. SAAs should monitor each of its subrecipients that receive federal funding subject to the administrative provisions of the Safe Streets Act to ensure that each subrecipient complies with its obligations in formulating, keeping on file, or submitting to the Office for Civil Rights in EEOP short form. The SAA does not need to evaluate the merits of a subrecipient's EEOP short form if the subrecipient is required to produce one. For subrecipients that need to develop an EEOP short form but do not need to submit it to the Office for Civil Rights for review, the SAA should, however, check during a desk audit or on-site visit whether the subrecipient can show that it has one. Compliance with the EEOP requirement may take the form of filing an exemption rather than producing and submitting an EEOP short form. For example, even though Indian tribes and medical and educational institutions are exempt from the EEOP requirement, they must still send a certification form to the Office for Civil Rights stating the reason for claiming the exemption. Additional information regarding a grantee's EEOP requirements can be found at the website for the Office for Civil Rights at www.ojp.usdoj.gov/OCR. The Office for Civil Rights has prepared online technical assistance that helps subrecipients comply with the EEOP requirements.
State administering agencies should monitor each of its subrecipients to ensure that each subrecipient with 50 or more employees and receiving federal financial assistance from the Justice Department of $25,000 or more has designated a Section 504 coordinator. As previously discussed, this person shall be responsible for coordinating the subrecipient's efforts to comply with Section 504 of the Rehabilitation Act, including 1. Investigating complaints of disability discrimination. The subrecipient should make available the name, office address, and telephone number of the coordinator. 2. Adopt grievance procedures that incorporate due process standards and that provide for the prompt and equitable resolution of complaints alleging disability discrimination. And 3. Notify program participants, beneficiaries, applicants, employees, unions, or professional organizations holding collective bargaining or professional agreements with the subrecipient that it does not discriminate on the basis of disability. The subrecipient should also provide notice on how and where to file a disability discrimination complaint. Also, as previously discussed, the Department of Justice's implementing regulation for Title II of the Americans with Disabilities Act also requires public entities with 50 or more employees, whether they receive federal financial assistance or not, to designate a disability coordinator and adopt grievance procedures. State administering agencies should monitor each of its subrecipients with educational programs to ensure that they, 1. Appoint a Title IX coordinator, 2. Implement grievance procedures for filing Title IX complaints, and 3. Notify interested parties that it does not discriminate on the basis of sex.
Also, as noted previously in the discussion of the laws pertaining to SAAs, the Office for Civil Rights Policy is to view subrecipients that lack civil rights grievance procedures as using methods of administration that have the effect of discriminating against program beneficiaries based on race, color, national origin, sex, and religion. The Office for Civil Rights recommends that SAAs encourage subrecipients to have a coordinator in place not only for disability and sex complaints, but also for complaints of race, color, national origin, religion, and age discrimination, as well as for retaliation complaints. SAAs should inform subrecipients that any discrimination complaints from either employees or beneficiaries may be forwarded either to the state administering agency or the Office for Civil Rights. SAAs do not need to require subrecipients to establish their own separate independent grievance procedures as long as the subrecipient has a written policy that states that it will send discrimination complaints, especially complaints from beneficiaries, to the SAA or the Office for Civil Rights. Law enforcement agencies are a particular class of subrecipients that should have detailed complaint procedures that allow members of the public to file discrimination complaints against law enforcement staff.
State administering agencies should also monitor each of its subrecipients to ensure that each subrecipient signs standard assurances that include all applicable federal civil rights laws and regulations. There is a separate online training program on the standard assurances for state administering agencies. The information would also be applicable for subrecipients. State administering agencies should also ensure that federally funded faith-based organizations, 1. Do not use federal resources for explicitly religious activities, 2. Complete and submit a certificate of exemption if they have hiring practices favoring co-religionists, and 3. Have a referral procedure in place for potential beneficiaries objecting to the religious nature of the organization. The Office for Civil Rights has prepared a separate training segment, available online, that provides detailed information on the rights and responsibilities of funded faith-based organizations. To ensure subrecipients' compliance with their obligations under federal civil rights laws, state administering agencies have a number of available tools which may include conducting desk audits, making periodic on-site visits, in providing training programs not only for its own staff, but for the staffs of subrecipients.
For on-site visits and desk audits, the Office for Civil Rights recommends that SAAs use a monitoring instrument such as a Civil Rights Compliance Checklist to evaluate a subrecipient's compliance with the various civil rights requirements that apply to all Department of Justice funded subrecipients, as discussed in this presentation. To assist SAAs, the Office for Civil Rights has prepared a sample Federal Civil Rights Compliance Checklist, which is available at the website of the Office for Civil Rights under the heading Resources Sample Documentation. SAAs may use or modify this checklist or develop their own to monitor a subrecipient's compliance with applicable civil rights statutes and regulations. The Office for Civil Rights recommends that an SAA provide periodic mandatory training to its staff to ensure that the staff is aware not only of the civil rights obligations of the SAA, but also of the civil rights obligations of the subrecipients.
The Office for Civil Rights strongly encourages state administering agencies to provide periodic training to all subrecipients regarding their civil rights obligations and responsibilities. The training should discuss the applicable civil rights laws and regulations and include a discussion of the subrecipients' procedures for referring discrimination complaints to the state administering agency or the Office for Civil Rights. The Office for Civil Rights has training materials on its website, including this training segment, which is accessible to subrecipients. Additional information about the responsibilities of state administering agencies is available at the website of the Office for Civil Rights at www.ojp.usdoj.gov/OCR. State administering agencies can also contact the Office for Civil Rights directly in writing at Office for Civil Rights, Office of Justice Programs, U.S. Department of Justice, 810 7th Street Northwest, Washington, D.C. 20531. You may also reach the office by telephone at 202-307-0690, by TTY at 202-307-2027, or by email at askocr@ojp.usdoj.gov.